Here we go. Bob Redden. Bob, how are you? Welcome, our dear friend and tortured hero.
Thank you very much for taking my call tonight, and say hello to all the crew. And I have to give kudos for Kevin for moving forward, even though the resistance is heavily on all of us.
Yes.
Well, thanks for saying that, Bob. The other half of that scientific team is sitting right here at the table. That's Jamie Lowell with Third Coast Compassion Center. Kevin and Jamie together on that project.
And Bob, you speak with what it sounds like to me a heavy weight on you. And I know it's been a terrible, terrible 3 years, because as long as even before the Michigan Medical Marijuana Act was official, Bob was being tortured. And many people may not know about the story. There's a lot of legalese and a lot of technical schnectical, and this court did that court did that, and that's fine, and there's a lot there and a lot to argue about. But what people don't really understand is the facts of the case. And I just want to say we know that there's a Michigan Medical Marijuana Act. We know that it was passed in November of 2008. The rules went into effect in January. Bob had been certified after that, but before a time that the registry department was making cards available. And a overzealous prosecutor's office decided to make a test case of Bob Redden and his loved one, Tori, who has cervical cancer and has been devastated at all levels from this. And what's interesting and what stands out in my mind is that early on, when the law was looked at as the law was, there was not a lot of politics. Some lawyers in the law, and Bob Redden and Tori went into court in front of Judge Turner in Madison Heights, and he looked at this law and said, you know what? This law says it's very, very protective. I'm going to dismiss this case. And
that was a rejoiceful day.
Wasn't it? And everyone said that's how it's supposed to be. Oakland County, District Court, and who knew that it was off to the, depths of hell from there, And Bob, it's ridiculous that it's even about you anymore. I mean, this is about everything other than what you are. I still don't understand what is it that they want to get from this. What is it that they really need to get from Bob Redden? You haven't been all through the court system on every single level, and now you're back and fighting more. It's like enough already. How much money did they spend? What do they want from you? How bad do they want to torture you in this 3-year process? Seriously, I know you don't have the answer to that. I want people to understand that this law
it might be the way I think about it. Sometimes it might be trying to reverse the Court of Appeals' opinion about being unregistered. I think that's a key thing. I think the Oakland County didn't like that decision, and I think that's what they were trying to get reversed. Because if that ever got open to the public and to the sick people here in Michigan, lots of people would not even attempt to get a card, especially if they had to wait for 6 months to 8 months for a card and know that their name and their address is being databased for law enforcement.
Yeah, what you're saying, Bob, is that with a Section 8 confirmation that we found in People versus Redden, the Court of Appeals opinion, which sent your case back down to Oakland County, it protected the Section 8 rights to patients, and they'd like to take that away from everyone because I think that's going to open it up to just everybody. We've seen that argument repeated all the last year through different courts. Bob, how you holding up, though? I mean, I know that you've got some things going on.
We're struggling, and we're really stressed. After we got an opinion from our new judge and basically in the last paragraph, she said that this law was very well written, very well understood. Any regular person would be able to understand this law back in 2009.
Yeah, and Cooper has been in the paper saying the same thing.
And you know what else? That's what Judge McMillan said in the Waterford dispensary cases as well, and she said ignorance of the law is no excuse. And I just pointed out, not to criticize Judge McMillan, I disagree with it, but I still, I guess, have to accept it. But Judge Daniel O'Brien in the Ferndale case said just the opposite. He said, in the Bob Redden case, there was 3 or 4 different opinions that have gone on. There's probably going to be more. In the McQueen case, there was several opinions that took place, and how can one how can any government agency, police force, the charging body that has the authority to prosecute, how can they hold the public to a standard of knowledge where they
higher than their own,
that they don't even know themselves? That's what this is about. That's what is so missing from this conversation. The most simple tenets of due process, which is notice and being told. You can't smoke. It's 100 feet from, prohibit smoking 100 feet from the building. Where can you smoke? 101 feet, 102, 103. Where can you not? Within 100, right? It's that simple.
Back 2 years ago, we were under the impressions where we were getting advices from attorneys saying, protect yourself, mark your jars, not ready, put dates on them, do this and do that. And all the time that we have been missing the point that you'll never get in front of the jury to be able to prove those points. Because we're not going to allow that, because we know if it gets to the juries are you're going to be not guilty, and the floodgates will open for us all.
The point of this is that they've used the law as a political tool rather than using it to protect patients and their caregivers, which is what it was supposed to be used for. And this is ultimately Exhibit A in the case for re-legalization. The only way that patients and caregivers will get any peace under these conditions is to legalize the whole darn thing.
No person should have to go through what you went through under the circumstances that it happened. They must think that you've been, trying to commit some kind of crimes, with there's some kind of intent, and that before you did it, you clearly knew and absolutely intended to, and knew what you could do and what you couldn't do, and looked the other way and did what you knew you shouldn't do. That's what a crime is. Did that happen in your case? Absolutely not. 3 years into this, for them to say that you should have known and that they knew. Let me give you my favorite quote so far in the 3 years that this act's been going on. It's when the Court of Appeals, the People v. Redden case, analyzed the two arguments that were made, one by the Oakland County Prosecutor's Office and one by the lawyers for Bob Redden. And when they looked at the arguments made by the Oakland County Prosecutor's Office, they said they're trying to somehow connect Section 8 to Section 7 to Section 4. And we reject that argument because clearly there are two parts to this act. There's Section 4 and Section 8. And essentially saying that how the Oakland County Prosecutor's Office is interpreting this act is wrong. That was the first ruling by the Michigan Court of Appeals. And that opinion was joined in the majority by Justice O'Connell, albeit he wrote a concurrent opinion, but they rejected that. And here we stand.
And we were okay with that decision about go ahead and reinstate the charges, let us go back to trial, let us have a jury, let the truth come out that, we not only had our front door locked where they used a battering ram on, but a lock in our bedroom, and that's still not enough locks.
That case that was in the Supreme Court last week, I don't remember, Bob. Did you wind up there? I can't remember that.
No.
Bob?
No, but I watched it.
That could make a huge difference.
They're talking exactly about this thing, about 8, because it talks about Section 7, and Section 7 starts out saying, in accordance with the Act, that means that you have to fulfill everything in Section 4 in order to be able to qualify to use Section 8. Okay? Automatically in that process, anybody that's been arrested is prejudged to be not qualified to use Section 8. Kind of interesting. I think that logic would flow there. But anyways, the court is looking at that, and I heard one of the judges ask an interesting question. She asked about the immunity section of the law, and I thought it was interesting that she knew that phrase. Michael?
Yes.
Did you catch that?
You know that I'm
immunity.
taking claim. Me and my cousin Aaron, who works in my office, who's an attorney, we take claim to the immunity because early on we said we got to start calling that the immunity section.
Yeah, I heard a Supreme Court judge use that phrase.
Congratulations. But we've been pushing it. That's you had to claim it and call it that because it's a separate kind of. But I'm not. That may be overreaching.
I just think it's
the lock secured environment isn't in Section 8.
Right.
That's a part of Section 4.
That's right.
It was optimistic.
It's not one of the things you got to prove to be able to get case dismissed under Section 8.
Well, obviously the judge didn't even read the transcripts from Judge Turner's courtroom, because the officers even testified in open court on it that there was a locking mechanism on the door. So that's what blows me away. We were in complete compliance with the act. There's no question about that.
Good.
No question.
Yep. How glad are you now, Bob, that your case is not in front of the Supreme Court like Mr. King and Mr. Kalanika?
Well, I don't know. I don't have much of a comment on that. Of course, you're going to think, the opposite of, after reading her opinion, you think that you're in more trouble now than you were then. But, that's just my own personal opinion. I don't want anybody to think this as legal advice.
Bob, I want to keep you on, so stay with us here. Our next guest, who you know very well, Sharmi Golson, is standing by. We want to talk to her, and I think we're having a little bit of some feedback on your call, Bob, so I want you to stay with us. I may put you on hold for a second, but then come back to you just to make sure that we get the line cleared out, but I want to get Sharmi Golson on. Sharmi, of course, is the co-owner and editor of the Midwest's first and only medical marijuana trade journal, the Midwest Cultivator. She was also a staff writer for LEAP, Law Enforcement Against Prohibition, an organization of law enforcement officers who speak out against and want to end the failed drug war. She is currently serving as the communication director for the Committee for a Safer Michigan and the ballot initiative to repeal marijuana prohibition for adults 21 and over. She is.
Please ask her to write about our story. We need help as much as we can get.
Well, that's what we're. Bob, you're absolutely right. And one of the reasons for us trying to get you on the show and get your story told is we're developing evidence here. Your story is evidence, and we're calling it Exhibit A in making the case for why we must repeal the marijuana prohibition now, because of people like you, 3 years into this law that was intended to be a shield and not a sword. If you're still getting tortured and dragged through it, and you've had to go through what you've had to go through, and the prosecutors can say things in court like, Judge, she only has cervical cancer, I think that it's time to, there's nothing left but to do this.